Hello, everyone, and welcome to today's program, Using ADR to Resolve Social Media Disputes, Neutral Strategies for a Digital World. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and I'm delighted to introduce today's speaker, Ellie Hurizadeh of JAMS ADR Services. Ellie is a mediator, arbitrator, court-appointed neutral, and neutral evaluator with more than 25 years of experience resolving high-stakes disputes across the United States and internationally. She delivers efficient, fair, and creative resolutions across countless practice areas, including disputes that arise or relate to social media, such as intellectual property, technology, artificial intelligence, and entertainment. She has served as a mediator for the Central District of California and Los Angeles Superior Court since 2019, and previously as a temporary judge for the Los Angeles Superior Court, and was repeatedly recognized as a preeminent litigator in Los Angeles by super lawyers. She also brings significant international experience, having represented clients in cross-border disputes through Europe, Asia, and the Americas. We can't wait to hear what she has to share with us today, so I'm going to turn it over to her.
Good afternoon. I'm Ellie Hurizadeh, and as just previously stated, I'm a mediator and arbitrator with JAMS. I specialize in cases arising from all types of social media posts, defamation claims, influencer brand conflicts, privacy breaches, and other claims arising and relating to contracts related to social media. In this session, we'll explore how counsel can use mediation not as a fallback, but as an advocacy tool to control the narrative of the dispute, to manage reputational exposure, and reach enforceable practical outcomes. We will also explore what arbitration provisions in social media agreements should include. I'm going to go ahead and share my screen with you. Mediation gives counsel a controlled, confidential forum to address what may otherwise be a very public dispute. This is crucial because public litigation fuels reputational harm, and reputational harm fuels social media disputes. Mediation can help shape the outcome through the process design, through mediator selection, and through tailored remedies. Mediation offers advantages like evidentiary flexibility and confidentiality, and it allows the parties to craft non-monetary remedies. Mediation can also help preserve client relationships so that the relationships can recover and possibly continue beyond mediation. Sometimes, when presented with the suggestion to attend mediation, clients view mediation as a waste of time, or worse, as a showing of weakness. As counsel, it may be helpful for you to frame mediation as a proactive risk management tool instead of a concession. You may want to try to explain to your clients that speed equals value in digital disputes. Any delay will likely compound the harm, the reputational damage, and the emotional association, and thus make it more difficult to resolve and more costly to litigate. Social media takes on a life of its own as soon as it's posted, and as a result, social media disputes escalate quickly, much faster than court timelines. Since the court system is always lagging behind, it is unable to afford either party the immediate relief that they seek, even in the case of temporary restraining orders or preliminary injunctions. Mediation and arbitration, on the other hand, allow for faster, technology-informed resolutions before the viral amplification of the issue at hand. And if the arbitration provision allows the arbitrator to issue preliminary action, like a takedown order, then the parties can get immediate relief while the dispute is being adjudicated. This can significantly reduce the potential harm and thus the damages. Digital disputes also often involve jurisdictional ambiguity in different social media platforms, each with its own rules and litigation requirements. This can further delay a final resolution and make it more difficult for the courts to be able to get all the necessary parties before that. We will discuss how these issues can be addressed by ADR. As you know, mediation is a confidential process that protects what is said at mediation. Mediation can also provide an arena for the parties to discuss and craft things like a joint statement to preserve each party's social media perception. This is important because in social media, Perception and reputational management is risk management. Reputation management is integral to resolution of these types of cases, and mediation gives you and your client an opportunity to control the narrative and prevent a winner-loser outcome. With the right mediator, parties can construct resolutions that are more creative. For example, settlements can include content modification, joint statements, restorative language, or carefully crafted correction. Counsel and parties can and should use their mediator both as a sounding board for public-facing language and as a means to craft with the other side a controlled narrative. Through the process of mediation, each party can participate in the joint outcome, which leads to more success, more compliance, and more likely that the parties may continue to do business after. In order for mediation to be successful, you as counsel must prepare your clients for the day of mediation. Preparing your client for mediation involves more than going over strategy. You need to help your client understand that mediation is a process. It takes time and patience, and explain to them that they will spend not an insignificant amount of time without the mediator in their room. There will be times when it seems that mediation is impossible and settlement is just out of sight, but you need to speak to your client and convince them to continue to be engaged during the process. Counsel should treat mediation prep like witness prep, anticipate emotional reactions, and have candid conversations about what it is that their client is really seeking to get out of the litigation. Remind your clients that mediation isn't about surrender. It's about taking control of the outcome. Use mediation as an opportunity to allow your client to advocate for themselves so that they can feel that they've been given the opportunity to air their grievances and explain their side directly to the mediator. There are at least 9 areas of consideration for counsel before and at mediation. First, you must determine what contract is at issue. In social media disputes, there are often multiple overlapping agreements. There's the written agreement between the party, whether it be an influencer agreement, a brand ambassador contract, or a content agreement. There's also the platform, Instagram, TikTok, X, YouTube, and the terms of that platform, which may restrict data scraping, affect ownership to the content or the account, and limit the party's ability to modify or remove content. And there are often side agreements in DMs, emails, or informal, we'll pay you if you post. All of these need to be taken into consideration. And in mediation, all of these should be on the table so that everyone is working from the same understanding of obligation and limitations. Second, social media disputes are highly evidence-driven, and the evidence is fragile. The evidence that drives social media disputes, whether in mediation, arbitration, or court, includes metadata and analytics. For disputes about performance or payment, it is imperative that you have access to and gather reach, impression, and engagement stats, follower counts over time, click-throughs, conversions, or promo code usage. It's important to have screenshots, but it's also important to understand that screenshots can be edited. You need to gather posts or comments or stories, but remember that each of these may have been deleted or edited after posting or limited in visibility either at the time of posting or subsequently by blocking users or restricting to close friends lists. All of this evidence is important and can be lost if it is not immediately preserved. Mediation can be an opportunity to share and gather information without formal discovery requests. You can ask the mediator for information from the other party that you need to make a decision or act or assess the other party's offer. You should gather as much of the metadata evidence as quickly as possible and have it available to support your argument for or against damages. The metadata helps anchor the value of your claim or any offer or counteroffer you may present. During mediation, at the very least, the parties should discuss and hopefully agree on how to preserve the metadata evidence during the course of the dispute, even if the parties don't reach a resolution on the day of mediation. Third, social media contracts often blur ownership. Before attending mediation, you should think about who owns the content. Does the creator retain the copyright and grant a license? Does the brand own the content? Is it a work for hire? Are there right of publicity issues outside of the social media contract? Is there a use of the brand logos or trademarks? And are these within the contract guidelines? In mediation, you'll want to have explicit discussions of what happens to the existing account, whether any content must be edited, removed, or recaptioned, and whether any licenses are revoked, modified, or clarified going forward. Fourth, social media often involves collection and sharing of personal or customer data, such things as email lists, customer lists, or DMs. If the alleged breach involved sharing or misusing of personal or customer data, during mediation, you want to discuss and consider the deletion or return of the data, or at the very least, cessation of use of that data during the course of litigation. 5. Before attending mediation, review the terms of use for the social media platform. Even if the parties reach a settlement in mediation, the platform policies might limit what's possible. You need to know who controls the login or administrative rights for the pages at issue. If the settlement includes transfer of ownership of a page or an account, can ownership be transferred under the platform rules? If an account has been banned or shadow banned by the platform, can this account be restored? My suggestion is that any settlement should focus on what's actually within the party's control, including promises that depend on the platform doing something may result in the undoing of your settlement. 6. Breach in social media context often centers on performance or payments. When you think about a breach, consider whether the breach is the result of performance issues that actually arose outside of the parties at issue. Is the breach due to outside factors like algorithm changes, seasonality, or platform issues? You want to consider and vet these issues before mediation and certainly before any litigation is initiated. In mediation, you'll want concrete numbers. You'll need to have the actual audience metrics or user metrics, the metadata that I just discussed. Some of this information has to be gathered from the platform, so you'll have to think about this in advance of mediation. It is important that this information is available to support your argument for or against damages and to anchor any offer or counteroffer you present at mediation, or to use it to undermine the other party's position. 7. If mediation results in an agreement, you want that agreement to be practical in a digital context. It needs to clearly and explicitly state which posts will be taken down or left up or edited, and when, a specific time frame, 72 hours. Second, you'll want and needs to verify compliance. How will the parties confirm that the screenshot or link has been taken down? Third, what is the process if a new harmful post surfaces later, or if the same harmful post resurfaces? Are the parties obligated to attend renewed mediation before initiating litigation? 8, if you're unable to reach a full resolution at mediation, try to reach an agreement on some very important preliminary points, like metadata retention, confidentiality of the mediation so there's no leak or post by either party, a joint statement about the dispute, or an agreement not to post further about the dispute until a final adjudication. Finally, social media relationships often involve cross borders. Parties may be in different states or countries, which raise questions about which law applies, whether the dispute will be heard if mediation fails? What is the forum for the dispute? At mediation, you won't decide these legal issues definitively, but you and your client do need enough clarity in order to shape a settlement that's likely to be enforceable where it matters and understand the risk exposure if mediation does not result in a settlement. Since social media relationships and disputes involve parties in different states or countries, online dispute resolution has become a more frequently used method for mediation and arbitration. ODR is simply mediation or arbitration that happens in a virtual setting. There are many options for ODR. I caution you to ensure that whatever company you choose as your online platform has sufficient security and data storage standards to protect your client's information. Data privacy implications under the California Consumer Privacy Act and the EU GDPR are important and required, especially when evidence includes personal data. You need to make sure that these concerns are addressed by the platform you use for online dispute resolution. If you're using JAMS, you don't need to worry about this, as all of these have been addressed by JAMS. In addition to security and storage issues, it is important to remain aware that sometimes virtual interactions can lead to tone misunderstanding and miscommunications, especially in a virtual session that involves people of different countries and cultures. For this reason, it is important to select a neutral with experience in social media matters and reputational management, as well as someone who has experience in global matters. I suggest that you treat your ODR like an in-person mediation. Control the lighting, the tone, the background. Optics affect credibility. You may also consider testing the platform with your client to ensure that your client is comfortable with such things as screen sharing and breakout rooms before the actual mediation or arbitration. I'm going to switch gears now to arbitration. More and more contracts include arbitration clauses. This is equally true for digital contracts, license agreements, brand and influencer deals. Whether you are drafting an arbitration agreement or reviewing a social media agreement for your client that includes an arbitration provision, you should ensure that the arbitration clause is comprehensive and not simply a boilerplate arbitration agreement. You may want to consider including a mediation arbitration alternative. The mediation arbitration alternative includes mandatory mediation at the outset of the dispute, which can result in lowering the temperature of the dispute. Initial mediation before arbitration can result in a preliminary agreement to take down or not post further, and it can allow the parties to exchange information at an early stage. There are 9 key things to consider when drafting or reviewing an arbitration provision in a social media contract. First, the scope. The arbitration clause needs to clearly state that it relates to all claims arising out of or related to the digital conduct or the conduct contemplated by the agreement, not just the contract terms. Otherwise, if either side asserts a claim that is anything other than a breach of contract, you'll be forced to litigate the case in 2 separate forums. The contract terms will be forced into arbitration pursuant to the arbitration provision, and all the other claims will be subject to court. If you don't want to be litigating in 2 forums, ensure that the scope of your arbitration provision is broad enough to include all claims arising out of or related to the digital conduct or the conduct contemplated by the agreement. Second, the arbitration provision should identify the forum of the arbitration. Otherwise, it will become a forum selection race by the first party to file. Is the arbitration going to proceed in JAM, AAA, or another third party? It should be identified in the arbitration agreement. Third, the arbitration provision should include any requirements for the mediator or arbitrator. The mediator requirements are only necessary if you opt for a mediator-arbitrator provision. Otherwise, you only need to include the requirements for the arbitrator. But the requirement should state that Does the neutral have to have experience mediating or arbitrating social media disputes? Do you want a retired judge? Is there a certain industry or specialization that's required? Whether you want specific requirements for your mediator or arbitrator, those should be delineated in the arbitration provision. Four, which rules is the arbitration going to be conducted in accordance to? Is it the JAMS comprehensive rules, the JAMS streamlined rules, the federal rules of civil procedure, the Federal Arbitration Act? Whichever rules you intend the arbitration to be governed by should be stated in the arbitration provision. Five, what is the controlling law? As we have discussed, social media involves parties and performance. They're national and sometimes international. Identifying the controlling law of the contract is one thing. Identifying the controlling law of the arbitration agreement is also necessary. You need to identify if the arbitration will be governed by California, another state, the federal rules. That needs to be included in your arbitration provision. Six, do you want your arbitration proceedings to be confidential? Many people mistakenly believe that arbitration proceedings are inherently confidential. They are not. If you want your arbitration proceeding to be confidential, you should state so in the arbitration provision. Seven, preliminary relief. Is the arbitrator permitted to issue takedown injunctions pending the completion of the arbitration? Is the arbitrator is the arbitrator have the ability to limit either side from making further social media posts or limit their social media conduct during the arbitration? If you want the arbitrator to be able to grant immediate relief at the outset of the arbitration, this needs to be stated in the arbitration provision. Eight, what type of relief can the arbitrator award at the end as part of the final award? Is the arbitrator permitted to issue an injunctive relief, a takedown order? Can the arbitrator prohibit a party from further postings? Can the arbitrator transfer an account, terminate the agreement, or award attorney's fees? You may also want to consider whether the arbitrator can add reputational remedies. If you want to have a limitation on what reputational remedies are available to the arbitrator, these should be set forth in the arbitration provision. And finally, the arbitration provision must address what happens if there's a conflict between the arbitration provision in your contract and the arbitration provision in the platform terms of use. As we've previously discussed, it is important as counsel to review the terms of use of the platform. But even if your contract arbitration provision is in line with the arbitration provision of the platform at the time the contract is drafted, there's nothing to say that the platform won't change its terms of use and its arbitration provision sometime before the dispute arises. Therefore, it's important for you to include a provision in the arbitration agreement that states that in the event of a dispute, the provisions of the arbitration provision of the contract should prevail. I'd like to turn to a case study for a recent case about a brand influencer dispute that was resolved through mediation. The case involved an influencer with a brand promotion contract. The influencer was accused of breaching the agreement after posting unapproved content, which the brand alleged damaged the brand's image. The contract had a mediation arbitration provision, and counsel invoked the mediation clause for mediation within 30 days. Attending mediation de-escalated the dispute and allowed the parties to air out their grievances and ultimately resolve their dispute. The settlement included a joint clarification post, a clarification of the contract terms that had led to the dispute at issue, very limited compensation, and an NDA on the disputed claims. The early mediation preserved the parties' relationship and prevented a defamation counterclaim and online fallout between the parties. For this reason, the mediation and arbitration provision helped preserve the parties' relationship and allowed the partnership to continue to move forward despite the disagreement. Courts now expect ADR provision in online contracts and social media platform user agreements. Platform user agreements are becoming more and more central to social media disputes. You need to take the arbitration provisions of the platform user agreements into account when drafting a social media agreement. A few recent noteworthy cases in this area are the Doe versus TikTok, where the court confirmed the enforceability of a click wrap agreement. And a click wrap agreement is where there is an arbitration provision in the terms of use, and the user is deemed to accept the terms of use simply by continuing to use the platform. There is no affirmative action by the user other than the continued use of the platform. Now, I will tell you that the current state of click wrap agreements is in flux, but many courts have upheld the click wrap agreements and thus held that users are subject to the arbitration provisions of the terms of use of the social media platform. Miller versus Meta Platforms, Inc., the court upheld the mediation requirements before class action lawsuits, and the parties were asked to attend mediation where ultimately the case was resolved. Smith versus Twitter, the plaintiffs sought injunctive relief in court, but the court upheld the arbitration clause in the terms of the use for then Twitter and declined to allow the plaintiff to proceed with its request for injunctive relief. Instead, the court ordered the parties to attend arbitration. The arbitration provision, however, did not provide for injunctive relief by the arbitrator, and as a result, the parties were foreclosed from seeking immediate injunctive relief. Many judges, especially those in the Central District of California, now build mediation deadlines into their scheduling orders. Mediation should be a consideration at the outset of any dispute. Like anything in litigation, the timing of mediation is important. In standard litigation, attending mediation before discovery opens, or before discovery closes, or before the court issues an order on an important motion like a summary judgment can all be impactful. But in social media context, the sooner the parties attend mediation, the more powerful it will be on minimizing reputational harm and avoiding an online public dispute. It will also help the parties gather and preserve critical audience metrics. Social media is global, and as a result, disputes arising from social media contracts or social media posts trigger cross-border data privacy and enforcement challenges. There are various international forums and procedures for data removal and enforcement. To avoid having to become proficient in foreign laws or having to litigate all or a portion of a dispute under the laws of another country, I highly suggest adding a choice of law and the ability for the arbitrator to order initial takedown to your arbitration clauses in your social media contracts. Some practical takeaways. Draft arbitration clauses that anticipate digital harm. Think about a breach. Think about what it is that your client would want to protect his or her reputation and include those in the arbitration clause. Select neutrals that are fluent in online dynamics and digital evidence. In the case of a mediator, the mediator can assist the parties in identifying, sharing, and evaluating the audience metrics that may serve as the basis for the damages. In the case of an arbitrator well-versed in online dynamics and digital evidence will better understand the parties' arguments and evidence. Gather your digital evidence as soon as the breach occurs. Even if your party is not the party that is alleged to have breached the contract, it is imperative for you and your client to immediately gather as much evidence as possible to defend against the claim that you believe may be asserted. Prepare your client to prioritize closure and control over public vindication. And as part of the settlement, include monitoring compliance, schedule periodic check-ins, takedown verifications, or other methods. Now, I know I went over a lot of things and probably too quickly. So I'd like to just recap by going through and summarizing the 9 things that should be considered before mediation and the 9 things to consider to put in your arbitration provisions. So I'll list them in without all of the explanations as we've already discussed. So for the 9 things to consider before mediation is identify the contracts, and they may not all be the contracts at issue that you're thinking of. 2, gather the metadata and analytics as soon as possible, and that may involve getting information from the social media platform. 3, identify the ownership of the content, the pages, the posts. 4, the data management. Consider whether the breach involves misusing of personal or customer data and how you can prevent further breach or disclosure of that data. 5, review the social media platform terms of use and rules so that you know what is permissible and what can be accomplished in mediation. 6, consider whether the breach arose as a result of something other than a bad actor, like algorithm changes, and vet those with the platform before mediation. 7, if mediation results in settlement, have clear obligations, a means to verify, and a process if there is the same or a similar harmful post. 8, settle as much as possible, even if not the entire dispute, at mediation. Consider metadata retention, confidentiality, joint statements, agreement not to post any further. And 9, shape a settlement that's likely to be enforceable where it matters, or if the matter doesn't settle, understand the choice of law issues and the jurisdictional issues so you know how to proceed immediately. And the 9 things to consider when drafting an arbitration provision that we discussed was the scope. Make sure that the scope is wide enough that it relates to claims arising out of or related to the digital conduct or the conduct contemplated by the agreement. Include the forum, JAMS, AAA, or another third party. Include the mediator arbitrator requirements. Number 4, what rules will govern the arbitration proceeding? 5, what is the controlling law of the contract or of the contract and the arbitration? 6, do you want your arbitration proceeding to be confidential? And if so, state so in the arbitration agreement. 7, is the arbitrator permitted to grant preliminary relief? 8, what is the arbitrator permitted to grant as part of its final order? And 9, if there is a dispute between an arbitration provision in the contract and some other arbitration provision, which one prevails? These are the case references. I hope that you found today's presentation helpful. I am happy to take any questions.
All right, so it looks like we have a, let's see, question from Jack asking if you'd ever acted as a mediator and then an arbitrator in the same case. Let's see.
I'm happy to answer that. Yes, so I have acted as a mediator and an arbitrator in the same case. There is a disclosure requirement that JAMS has the parties sign, but the arbitrator can serve as a mediator in the case if the parties agreed to do so. In the case that I served as the mediator for a case where I was selected as the arbitrator. The parties ultimately settled in mediation, and so we didn't go back to arbitration. And so that case was resolved in mediation. But yes, the arbitrator can serve as a mediator under the JAMS rules. I don't know whether or not that's true for AAA or any other organization, but I can only speak as to the JAMS rules.
All right, so it looks like we have some questions from through email. I guess we can attend to those while we wait for our audience. How do you persuade a client who wants public vindication that ADR is actually the better strategic move?
That's a great question. So oftentimes it takes a lot of persuasion and a lot of discussion with the client of if you want online vindication, you have to remind your client that the online vindication will happen on both sides. So unfortunately, it's not just your client that's going to be posting and messages on social media, but it will be the other side as well. And then there's a whole comment section that takes on a life of its own. My suggestion would be perhaps have an example of something that's already happened for your client with regards to the dispute. And it often happens in a chat or the DMs. And try and have your client imagine a world where that takes on a life of its own. And you can explain to your client that once the genie's out of the bottle, it's very hard to put that genie back in the bottle and to regain reputational damage that was lost as a result of a dispute that takes place in the public forum.
All right, then I have another question. In your experience, what kinds of non-monetary remedies, for example, joint statements, content edits, retraction language, are most effective, and which ones tend to backfire?
Well, in my experience, I find that joint statements or things that are done together between the parties are the most effective. So where the parties work together and come to a settlement, and by settlement, I mean each party has to give on what they want. If the parties can come to a joint statement or a joint concession on what is stated, those are the ones that are most likely to result in compliance and resolution. The ones where the parties say, okay, we'll each issue our own statement are the ones that usually result in more discourse between the parties. Once the parties come to a joint statement, they have more incentive to comply and to reinforce the joint message that has been put forth. So I always advocate for something that's joint. And even if each side is going to issue their own statements, I often advise that they compare or share their joint statement with the other side before posting to avoid further escalation of the dispute by unintended consequences of what is meant to be a cooperative statement that isn't interpreted as such by the other party.
How would you prepare a client who is emotionally charged because the dispute played out publicly online?
I would I would actually not try and disengage the client from the emotion. I would advise that counsel let that client that is emotionally charged be present at mediation and have the client present the case in their view with all of their emotion to the mediator. I think part of moving a case forward, be it in mediation or ultimate resolution in arbitration or court, requires the parties sign on. And in order for a party to sign on, they need to be able to be heard. And sometimes the only place that a party can be heard is at mediation with the mediator. So bring your client that's charged, emotionally charged, to mediation and allow your client to speak directly to the mediator and allow the mediator to validate and vindicate the client in your private caucus with respect to how your client is feeling and how your client feels it has been wronged.
Alrighty, and another question. What specific language do you recommend to ensure the clause, an ADR clause, I'm assuming, covers tort claims arising out of digital conduct?
So the language that I found through my own practice and through ADR and through court review is if the language includes language that says arising out of or related to the digital conduct or the conduct contemplated by this agreement, usually that is broad enough to include tort claims. You can, of course, say including but not limited to any tort claims that arise from or were related to claims arising from this contract to be overly inclusive. But I think it's important and it would be in your client's best interest to include more words and to be broader in the scope of your arbitration agreement than to be forced to litigate in two separate forums.
All right, and let's see. When drafting clauses that allow arbitrators to order content removal or correction, how do you avoid running afoul of platforms' own policies or technical limitations?
So the arbitrator is going to look to counsel for that. I mean, any good arbitrator is also going to look at the platform rules. But when counsel is seeking to have either a provisional remedy at the outset of arbitration or as final remedy, part of counsel's job is to ensure that whatever remedy they're asking the arbitrator to provide is in compliance with the platform's rules, and it's in compliance with the then effective platform rules. So the arbitrator will look at the platform rules, but it's really counsel's obligation to make sure that whatever they're asking for is something that the platform will allow the parties to do. So even if the arbitrator it issues a final award or a remedial award at the outset to say take down X, Y, or Z, even if the courts go to court and have the court enforce that order, if it does not comply with the platform rules, the platform doesn't have to do it. So make sure that whatever you're asking for from the arbitrator, the mediator, or the other side or court, it conforms to the rules of the platform. So study the rules of the platform, see what it is that they, in terms of ownership, in terms of litigation, and in terms of what can be done as remedial effects for an arbitration or remedial remedies, make sure that whatever you're asking for conforms to what the platform will allow.
Alrighty, and so it looks like we have another set of questions. When using mediation mid-litigation to test a damages model, what makes that process most productive for the mediator?
So if you want to test your damages model in mediation, the best way to do that is to test it with the mediator. So present your damages to the mediator as if they were the judge rendering a decision in your case. The mediator will walk through the damages calculations with you, and a good mediator will be able to identify to you and for you the areas of your damages calculations or damages strategy that are not likely to be successful. So you can use your damages. So first have the conversation with the mediator. And once you have tailored your damages strategy and your damages claim more narrowly so that it fits within the law and within your claims and has a more likelihood of a success, then you can present that via the mediator to the opposing party at mediation. But you should flush out your damages strategy with the mediator first.
All right, and let's see. What are the best practices for drafting mediation briefs that both support settlement and preserve the litigation narrative if mediation fails?
That's an excellent question. So I strongly suggest that mediation briefs not be like a court pleading. Your mediation brief should set the tone for mediation, both with opposing party, if you're going to share, and with the mediator. So the mediator is going to know, and obviously the opposing party knows all of your claims and knows the law. You don't need to spend a bunch of time reiterating what the law is. You can identify the claims and then identify the facts that you believe support your claim or defense. Then use the rest of the mediation brief to explain to the mediator what happened and the personalities that are going to be present and what has prevented the parties from reaching a resolution absent mediation. Those are the things that help the mediator help you reach a resolution. Now, if you're going to share your mediation brief or a portion of your mediation brief with your opposing side, which can be helpful, then the tone of your mediation brief can set the tone for mediation with the other party. You can use your mediation brief to explain away something that may be misunderstood or an inadvertent mistake, and set the tone with the other party to try and explain your position without being adversarial.
Right. So let's see. In high reputation risk cases, how do you balance zealous advocacy with the ethical risk of inadvertently disclosing sensitive information that could be leaked or misinterpreted?
That is a difficult tightrope to walk. In mediation, you want to ask the mediator to re-emphasize at each time they go into each room that the information that's being disclosed is confidential. Now, counsel knows that, but parties who have not been in mediation before often forget that. And so that needs to be reiterated at every stage of the mediation so that the parties are constantly reminded that whatever is being said today cannot be used, weaponized, or posted later. Second of all, if you are producing paperwork to the other side that includes highly confidential information, keep track of whatever it is that you're giving to the mediator to share with the other side. Make sure you get all of your paper back. Now, I understand that the other side can take a picture, so it doesn't foreclose absolutely the disclosure. But if you're keeping track of the paper that's being disclosed, you can avoid the inadvertent disclosure later by someone who retains the piece of paper that has the information and later forgets that that was produced in mediation. So you have to be really vigilant in the disclosure, keeping track, and also making sure that the mediator reiterates repeatedly that the information, whatever is being disclosed, is confidential and cannot be used by either party outside of the confines of mediation.
Are there any recurring ethical issues you see when lawyers negotiate non-disparagement or joint messaging provisions?
I don't see it as reoccurring ethical when they do joint statements, or, but I do see ethical issues when people are zealously advocating on behalf of their client. So there is there's a fine ethical line between being deceptive and doing puffery. So you need to be able to walk the fine line of being able to zealously advocate for your client and puffing when necessary to try and get the best settlement for your client versus being deceptive, excuse me, and not disclosing something that the other side doesn't know or has no reason to know, but is in the knowledge of your client. Something that later will come up and cause the other party to undermine the settlement or to allege fraud.
All right. So let's see. How do you approach a mediation where the narrative the client wants to preserve is factually inaccurate or self-serving, and managing that narrative itself becomes a barrier to resolution?
That's a great question. So I would do it in two ways. I would include, if your client insists on including its version of the narrative in your mediation brief, then do so. Put it in the mediation brief. I would caution that perhaps you don't share it with the other side because that will set a bad tone for mediation. If the other side gets a mediation brief that is inflammatory or contains facts that aren't true, but I understand your position in having to set forth the facts that your client wants to set forth, even if not true. My suggestion is have a confidential brief that you're just sending to the mediator that sets forth the facts as your client wants. I would subsequently also submit a further confidential statement to the mediator that explains the personalities and suggests to the mediator that some of the facts are subject to interpretation. A good mediator will know the difference, and the good mediator will come to mediation, spend some time with your client, and ascertain the true facts by questioning your client in a non-aggressive manner to try and understand what the true facts are. The mediator can serve as the person who will question and put doubts in your client's facts so that your client can come and reach more certainty and reality with respect to the facts of the case.
Let's see. What do you see as the practical limits of enforceability when a remedy depends on cooperation of social media platforms or the dynamics of algorithmic spread?
That's a great question. It is very difficult to come up with, to arrange for settlements that require social media platform compliance, or for them to do something with their algorithm. And I imagine you're talking about banning or shadow banning. It is very difficult, and we've had very little success in getting the platforms to do something simply because the parties' settlement agreement requires it. The best thing I can suggest is to reach out to the platform by counsel ahead of time. You can subpoena their rules, and they have an internal set of rules, or I think some of them call it dispute resolution. And some of the platforms, I know that TikTok does not, but I know that some of the other social media platforms have something that they send to counsel that will outline what it is that the parameters of what they will or will not agree to do. You can ask for that. It's important to reach out to the platform, sometimes through general counsel, and find out what are the limitations of what the platform will allow and has allowed in the past. And you can use that as kind of a guideline. Otherwise, it's kind of like shooting in the dark and hoping that the platform will agree to what the parties agree in settlement. And so that's why it's important that the parties try and agree to things that are within their rights and abilities outside of the social network platform itself.
All right, so it looks a little bit kind of going backward in terms of emotion. What is your view on whether mediation risks becoming too data-driven in reputational cases? And how do you balance hard metrics with human impact, emotion, or apology dynamics?
So I think I forgot the first part of the question, so I'll have you repeat that in a moment. But I think balancing of the metrics versus the reputational harm and the emotional harm that people feel is much easier in arbitration than it is in in mediation, excuse me, than in any other forum. Mediation allows the parties to, for example, apologize. And I had a mediation where the apology went a long way in resolving the social media dispute. Mediation is the only forum that allows for that personal touch. Now, while you may spend a lot of time in separate rooms in mediation, a good mediator will know when it is appropriate to have the parties in the same room. A mediator can take the apology to the other side and say, are you open to this? Would you be willing to accept an apology, to hear an apology from the other side? Because that's important. I think diffusing of the emotional baggage that comes with litigation is important and can only be done in mediation. And that needs to be done before any of the metrics or anything else can really come into play. So I think that's an important part, and I'm glad that the audience is recognizing that. If you don't mind reading back the first part of that question so I can answer that.
Yeah, it was what is your view on whether mediation risks becoming too data-driven in reputational cases?
I don't think mediation is too data driven in any of the cases. I think mediation primarily is about people and what they're feeling and the emotions. And then once we get past that stage, then we can drill down on the numbers and talk about the reputational and the metadata and how we address that reputational harm that's happened in the numbers. Like in social media, things are moving so quickly that the numbers often by the time you reach mediation, and certainly by the time you reach arbitration or court, have already become moot. And so it is the personal feeling and association that matters more at mediation than the metadata at this point.
All right, and it looks like I have one last question here. Um, how do you identify and correct for a power imbalance where one party is technologically sophisticated and the other is not? Especially when digital literacy itself is part of the dispute.
That is a more difficult bridge to a more difficult bridge to cross. However, my suggestion is, in anticipation of litigation, become as counsel and for your client, become as proficient as possible on the social media platform that's at issue, or on whatever the technology is that is at issue. Become as proficient as you can. Use AI to learn about it, to learn about what can be done on the platform, what could have been done differently to avoid the dispute. And then at mediation, ask the mediator to have the other side help you understand the technological issues that are that you feel there's an imbalance or that is becoming an impediment for you to reach a resolution or to reach a decision. There is nothing wrong with you asking the other side to educate you during mediation, but that's really the only forum where the other side has the ability and the opportunity to educate you without it being adversarial.
All right, perfect. So that looks like that's our questions for today. Thank you so much, Ellie, for a fantastic presentation. And I'd also love to thank our audience for joining us this afternoon. Have a great day, everybody.
Thank you.